Welcome back. The Office of the Labour Commissioner has issued a strong directive to curb unnecessary postponements in conciliation and arbitration hearings. Now, with a growing number of delays threatening the efficiency and fairness of labour dispute resolution, the new measure aims to ensure that cases are heard on time and that parties come fully prepared. And to help us understand what this means for workers, employers, as well as the labour justice system, we're joined by Advocate Fabiola Katjivena, an advocate at Tjitemisa and Associates, to give insight from a legal point of view, or rather I should say a labour lawyer. Fabiola, thank you so much for joining us this evening here on the Daily Roundup. We appreciate it.
Thank you.
Well, from a legal standpoint, as I mentioned, how significant, Fabiola, is the Office of the Labour Commissioner's new directive, on reducing postponements of the conciliation and arbitration hearings?
The new directive, I should say, should be seen as a reinforcement of what was meant with the new dispute resolution for the speedily, obviously, resolving of labour disputes. So without postponements, at least disputes will be resolved faster and speedily.
So, in your experience, how have frequent postponements affected, timely resolution of labour disputes in Namibia?
Adversely, because obviously parties want the dispute to be resolved, but with postponements, obviously there are delays, backlogs, so it has really affected the whole new dispensation in a negative way.
Could the stricter enforcement of timelines create challenges, perhaps, Fabiola, for legal representatives who, need proper time to prepare a case?
It is really a pity that the Labour Commissioner in the directive mentioned perhaps unpreparedness as a reason for the postponements, because parties are given ample time, from when the dispute is registered to when parties are called for a first meeting, which is conciliation. So it shouldn't be seen, unpreparedness shouldn't be seen as a reason, or shouldn't be even regarded as a reason for parties to postpone the cases, because there is enough time for parties to prepare for the case. And
would that not be relative, depending on who the legal representative is?
Not at all, because obviously, like I'm saying, parties are given ample time before the notice of set-downs are given well in advance. It's not a last-minute thing to say that no, I only became aware that my case is tomorrow. No, so that can never be reason enough to postpone matters, and it should never be entertained. Yes.
Do you foresee any legal challenges, Fabiola, or debates arising from this new directive?
Not at all. Perhaps, because obviously there is a part of the rules of the conduct for conciliators and arbitrators is that parties themselves can agree on a postponement. So if that happens, perhaps, but it has to be handled with care. But other than that, obviously, unless there is a genuine request or a valid reason to seek postponement, other than that, I think it is in the best interest of everybody involved for parties really not to postpone matters or to ask for postponements unnecessarily. So I don't think there will be any legal challenge unless there is malice, but I don't even know what malice will be there.
Right. What advice would you give then to lawyers, employers and employees to adapt effectively to this new directive?
I would say, obviously, it is the role of a lawyer, or it is the duties of the lawyer or the mandate of the lawyer to make sure that the clients, obviously, are well represented and that their interest is taken to heart. But when it comes to postponements, there are obviously there might be reasons for postponements. But what one can say is that from now on, for parties to try and avoid postponements, for parties to try and resolve matters amicably also, because there are, as much as cases are referred to the Office of the Labour Commissioner, there is always also room for parties themselves to try and resolve matters on their own. So It's just for parties to try and see what the mandate of the new dispensation was. That was for the speedily resolving of labor matters. But now, if parties or if lawyers, perhaps that are there to assist the parties in reaching these settlements or settling these disputes, go about asking for unnecessary postponements, then obviously that will defeat the whole course of the new dispensation. But I think all in all, we are all human. Problems will be there here and there, but at least to try and minimize that and to pay attention to their clients and to try and also, I don't know how to put this, but you know, when it comes to labor cases, there are expectations, obviously.
Of course.
Obviously, also just to be very, very, very open with the clients when it comes to the cases, the prospects of success and everything.
Yeah. Well, this evening, later on Talk of the Nation, Denver Keesting and a panel of legal experts will be dissecting and unpacking this directive from the Labour Commissioner. So right after the Daily Roundup, you can tune into Talk of the Nation to catch an expansion